Good to see everyone. Sorry we had to reschedule last week. As you know, if anyone in the world needs health care these days and a doctor says you can come in, I will see you. You go to that darn doctor, right? Because otherwise you're going to be waiting 3 or 4 months. So nothing crazy. I feel fine, but I tweaked my knee a little bit, and it's really hard to get an appointment with an orthopedic person. So when they say you can come in, I go. What's up, Larry? Long time no see. So hi everyone. I think everyone's in now. We good, Crystal? Today's topic. So let's go dog of the day first. So that is Nala. That's Donna Barber's from First Service. Dog, huge dog. Looked like he could devour you. Huge dog, but I'm sure very friendly. Has a little drool there, so I don't know if my wife would allow that dog in our house because it would probably destroy our couch. But beautiful, beautiful dog. Very nice dog. Thanks, Donna.
Looks like a Bernese Mountain Dog, I would guess.
Yes,
Beautiful.
Tibetan.
She's a Tibetan Mastiff.
Yeah,
Tibetan
Tibetan
Mastiff.
Mastiff.
Ooh, nice.
Huge dog, really nice. So the other thing is too, I wanted to recognize Kathy Stewart from Gateway at Roycebrook. So Kathy is the one who requested today's topic. So it was a very timely request because the case just came out last week. So we said, hey, awesome, Kathy, we will do it. And it's an interesting topic, even though my topic says, but we knew that already, didn't we? So for those who've been attending First Fridays with Fran since COVID began, I guess that's like 4 years now. Time flies when you're having fun. You've heard me talk about this in the past. Can age-restricted communities restrict ownership of the units based on age and familial status? The answer is no, right? And I've said that over and over and over. Notwithstanding that, various people have disagreed on that, and we have finally gotten a really clear decision from the appellate division on that answer, which is nice. This is not the first decision on it, though. So if we're tracking the agenda today, let me take a step back. I got to make my announcements so nobody says Fran McGovern said this, and now I'm going to sue Fran McGovern. So these webinars are for educational purposes only, and informational. They're not attorney-client relationship. They're not legal advice. If you need legal advice, either call us if we're your attorneys, or hire us if you're not. But if you don't want to hire us and we don't represent you already, you have to speak to your own attorneys to get legal advice. So you have to contact your attorney directly. Also, and I say this every time, nothing is confidential. So please don't say confidential things like, "Oh, Fran, we've been keeping young people out of our association forever, and we knew about it and we don't care." So don't say that, because that will be broadcast everywhere and recorded, and you will probably get sued. So don't do that, please. So, but thanks again. And so the first topic is the beginning. Where did this all start? So even though this case just came out last week, really this case started a long time ago. So this is the Holiday City Homeowners Corporation versus Scott Carrico. They say it two different ways. Carrico case. So Mr. Carrico purchased 2 homes in Holiday City. And I don't represent Holiday City. I'm not involved with the case at all. But so he purchased 2 homes back then, and Scott was 53 at that time. So he was 2 short years of being 55 years old. Nevertheless, Scott never lived in those homes, right? So he never lived in the homes. He was a flipper, and he was also a realtor. And he said, hey, wait a second, guys. All I'm doing here is I'm owning them. I'm going to fix them up, flip them, and try to make some money on the flip and make the community a nicer place. And the associate said, wait a second, Scott, you can't do that. And that's a violation because we have a provision in our governing documents that says you cannot own them. You cannot own them. It's not an occupancy restriction. Our document says you can't own them unless you're 55 or older. So they went to litigation. They were fighting over, they claimed Scott owed some money. I think it was about $700, and then some, perhaps another $300. And it went to the trial level. And the trial level judge said, you know what? Yes, Scott owes the money. It seems that the trial judge kind of sided with Holiday City and said, yeah, you know, Scott, you're breaching these governing document provisions. However, the big problem there was that the association had spent, I think, more than $20,000 in attorney fees. And the court said, we're denying your attorney fee request, however, because we thought this was an arguable issue in good faith. And there were some other technical reasons for that. But it went to the appellate division, right? So both sides appealed. Holiday City appealed, saying, wait a second, the trial judge messed up. We should have gotten our attorney fees and we should get them all back. And our friend Scott said, yeah, this wasn't right. I have every right to own things. I don't have to occupy them, but I have every right to own things under the Fair Housing Act and New Jersey's law against discrimination. So we went to the appellate division. And again, this decision came out in, it was argued in 2020. The decision itself came out in 2021. And the appellate division came back and said, well, we're going to affirm the trial court's decision not granting attorney fees. And we are going to render the case moot because in the meantime, Scott had sold his 2 investment properties. And we're going to affirm the trial court's decision as to whatever the $750 or the $800 or $1,000. So like we talk about a lot of times is how much justice can you afford, right? A lot of times these cases are about attorney fees, right? And many of you who are on the call today know that we have either been involved in cases or not been involved in cases where a lot of times what goes into the calculus is attorney fees. So in this case, the association, in some respects, won the case, but lost the attorney fee application and really didn't get much out of it. The thing to know about the Holiday City case is that it's in the same township. Oddly, and I don't know why they did this, Holiday City also named Berkeley Township as a defendant, okay? They named Berkeley Township as defendant. If you want to read something about how the FHA applies to age-restricted communities, these 2 cases together provide an awesome overview. I was talking to Barry Goodman earlier today from Greenbaum, who did a great job in this case, and I should mention his associate who worked on it brief, Connor Hennessy. So I was talking to Barry, though, earlier today, and I said, this is a great decision. Really, I could probably use these 2 decisions that the court wrote as just seminar handouts. They're written so well, especially the most recent decision. So if you just feel like to do some free time reading, I know Larry, I'm sure, would love to do that. You can pick up these cases. They're on the internet, or we can send them to you. But so like I said, this case, the first case, the Holiday City versus Carrico and Berkeley Township, is really just the beginning of the case that was decided last week. Because after the case was dismissed by the appellate division in Carrico, what happened? Berkeley Township amended its ordinance to say you can't own units if you're 55 or younger, right? So that triggered the follow-up case that we're talking about today, which is New Jersey Realtors versus Township of Berkeley. And if we go back to the Holiday City case for a second, there's something in the law called an amicus brief that can be submitted. And you'll notice that in the Holiday City case, that Barry Goodman actually filed an amicus brief in that case on behalf of New Jersey Realtors, trying to get this ownership restriction stricken. But since the court said it's moot, and what moot means is it's no longer an issue because my friend Scott sold the house, so there's nothing to fight over, no decision to make, we're not going to address the issue. So courts only address, for the most part, very rarely with exception, do they address cases that do not have what's called a real case in controversy, a real case in controversy. So that's why, sometimes when I'm standing at the front of a board meeting and we say, hey, this issue in the law has never had a court decision on it. And the membership says, well, Fran, why don't we file a lawsuit and see what a judge would say? Well, you just file a lawsuit just to get an advisory ruling from a court. Courts generally don't just issue advisory rulings. You have to have what's called a real case in controversy, which 2 people are fighting over something. And then after this case was dismissed as moot, and the township went back and amended the ordinance to provide for restriction on ownership for those 55 and younger. Barry and his associate on behalf of the New Jersey Realtors, sued the Township of Berkeley based on the ordinance. So the Holiday City case was based on the governing document provisions. The Township of Berkeley case was based on an ordinance that had been adopted after the Holiday City case restricting ownership. And that is a distinction, right? So generally speaking, even though, in my opinion, the courts would set aside both, if they had reached the decision as to Holiday City's documents, they would have set aside Holiday City's governing document provisions. The court in the Berkeley case also struck Berkeley Township's ordinance provisions. Courts look even more strictly at government action than they do at private action. So Holiday City would have been a private restriction, more or less, and Berkeley Township's ordinance would have been a governmental restriction. Like I said, courts tend to scrutinize government action much more strictly, but I believe in this instance, the courts would have stricken both of them anyway. The interesting thing also about the Holiday City, talking about attorney fees, not only did they went to the trial judge, then they went to the appellate division, right? Then they went to the appellate division, spent more attorney fees, and then they applied to New Jersey's Supreme Court to try and get the decision overturned at the New Jersey Supreme Court, even though the appellate division in the Holiday City case said it's moot. My man Scott already sold his place and moved away, or sold his place and made his money. They applied to the Supreme Court for what's called certiorari, to asking the Supreme Court to rule on the issue, and the Supreme Court is not obligated in most instances to take the case. So when you have members, and you've all had members in your audience say, I'm going to take this to the top, I'm never going to settle, I'm going to take this to the Supreme Court. The Supreme Court is not obligated to take all cases. There are some exceptions to certain types of cases must go to the Supreme Court, and the Supreme Court has to take them. But generally speaking, the New Jersey Supreme Court has discretion as to what appeals it takes. The interesting thing, and Barry and I talked about this morning, I asked Barry Goodman if this Township of Berkeley case was going to be appealed to the New Jersey Supreme Court. And he said he hadn't heard yet. He hadn't spoken to Berkeley Township's counsel. I'm sure the attorneys involved in the case have a cordial relationship, but he did say that, of course, if the township wanted to, they could. An interesting wrinkle on this is that in this case, technically, the people who were unsatisfied with the outcome, Berkeley Township, I guess, in this case, could apply to the New Jersey Supreme Court for a hearing, or oddly, the United States Supreme Court for a hearing. And the reason for that is this case deals with federal law, the Fair Housing Act, which is a federal law, and the law against discrimination, New Jersey law against discrimination, which is a state law. The federal Supreme Court would probably say that you have to exhaust your remedies at the New Jersey Supreme Court first, before the federal Supreme Court, the United States Supreme Court, would take a look at it. But oddly, under this case of Township of Berkeley, in theory, both United States Supreme Court and New Jersey Supreme Court could take jurisdiction of it, because it involves state and federal anti-discrimination laws. So Fair Housing Act and familial status discrimination, this has always been confusing to me, right, through a lot of my career, because don't we all talk about restrictions in the context of housing and adult communities as age restrictions, right? Age restrictions, so weird, right? This is what the Fair Housing Act prohibits. The Federal Fair Housing Act prohibits discrimination based on not many things: race, color, religion, sex, national origin, and familial status. Familial status. So that's why these cases don't necessarily turn on age, okay? It's what's called familial status, and familial status is defined generally as one or more individuals who have not attained the age of 18 years old, being domiciled with a parent or another person having legal custody over such a person, right? So what does that speak to? Basically, families with children. It doesn't have to be mom and pop with children. It just has to be living in that relationship. So it could be an adoptive person, etc. So the Fair Housing Act broadly prohibits illegal discrimination in the context of housing. However, how do we get active adult communities then? There's a subsequent law called HOPA, the Housing for Older Persons Act, for Older Persons Act, which carves out what's called a safe harbor that protects these unique types of communities, often called age-restricted communities. Most of you might live in age-restricted communities. And the only way to take advantage of that safe harbor is that you meet the requirements of the safe harbor exception. So basically they're saying you can discriminate based on familial status. You can discriminate based on familial status if you can show that 80% of your homes are occupied by a 55 and older person at a minimum. And there is some other stuff that you have to be able to show it in good faith, et cetera. You know, we've talked about over and over the various surveys you should be doing every 2 years to make sure that you meet the minimum 80% threshold. Because if you fall below the 80% threshold, you lose safe harbor status, right? And you can no longer be an age-restricted community because you will be discriminating based on familial status without having the benefit of the safe harbor. You will get sued, you will lose, and you will pay tons of money in attorney fees.
And Fran, just to clarify, I think that also goes along with having somebody residing there that's under the age of 19, right? Because it's 19 and older
Right.
to age 55, because
Yep.
that comes up fairly often.
Right. So we wind up, for those of you who don't know, we wind up in lawsuits at times where people are violating the having children in the homes, and we have to take action to address that. Now, the other part of this case is that we talked about that's the Federal Fair Housing Act, and HOPA, right? Housing for Older Persons Act, which is the safe harbor, that you have to make sure all of you qualify for that. Every 2 years, you have to get the required proofs to make sure you qualify for the safe harbor. But the New Jersey law of discrimination also applies. New Jersey law of discrimination, most people call it LAD, LAD, or NJ, LAD, New Jersey LAD, has very, very similar prohibitions and actually even broader prohibitions, right? Broader prohibition. So when we were talking about the Federal Fair Housing Act, even though there were only 6 expressed prohibitions, if you will, case law has expanded those prohibitions. So, for example, discrimination based on sex, maybe at inception, people thought, oh, well, does that mean if I discriminate against men or women? That's what sex is, right? Well, the subsequent case law has expanded that into various other areas, such as same-sex relationships, trans status, and things like that. So even though the statute expressly only says those things, be careful and speak to your attorney if there is an issue, because generally speaking, those express items have been expanded by case law. The New Jersey law of discrimination, however, is much more expressed than the Fair Housing Act. So I'll just read, because people are often talking about discrimination, and as I've said many times on First Friday with Fran, discrimination in itself is not illegal, right? What is illegal and prohibited is illegal discrimination, right? Because, like I said, I always wanted to be an NBA star or a Major League Baseball player, but people discriminate against me because I'm not a good basketball or baseball player. Well, that's okay, because you're allowed to discriminate against somebody because they're not a good basketball or baseball player, right? But what you're not allowed to discriminate, especially in the housing context, is the following things under New Jersey LAD: race, creed, color, national origin, ancestry, marital status, civil union status, domestic partnership status, pregnancy, breastfeeding, sex, gender identity, or expression of affectional preference, sexual orientation, familial status, we heard that before, disability, liability for services in the armed forces of the United States, nationality, or source of income used for rent and mortgage payments. So the New Jersey lad is much more expansive in terms of prohibitions against discrimination. And that's why some associations, and we've bumped into this a few times, will say, well, we don't want Section 8 people living here. And for those of you who don't know, Section 8 is a program through the state, administered by the state, that provides rental assistance, housing assistance, financial assistance for housing. And we get asked that question, can we prevent that? No, the answer is no, because just because of the fact that they're getting their funding for housing paid for by a state program or a federal program, you can't discriminate based on the state law against discrimination based on their source of income. Okay, so that's the New Jersey lad. And let's get into some things about the case. So now we're basically, so there are the types of discrimination under the Fair Housing Act and LAD, and they're fairly exhaustive. So basically, always pause and contact the association's counsel if there is any question about the association trying to limit somebody either buying into your community or moving into your community to reside in the community. It is an area that is fraught with risk for litigation and attorney fee shifting. Okay. So state preemption of local ordinance, that's the next topic, state preemption of local ordinance. So as we talked about, we have the federal law and the state law. Here, Berkeley Township adopted an ordinance that says, hey, you can't own a place, a home in our community if you're 55 or younger. And the reason that Berkeley Township stated for that was the township wanted to, allegedly, it was reasonably calculated to address the local concerns. They were concerned with rampant house flipping and speculation by non-owner occupants, including corporations and persons under 55 years of age, which is making communities unaffordable for the very persons they intend to serve, seniors on fixed incomes. Right. And as you might imagine, there's a problem with that, right? Because we have the Fair Housing Act, which is a federal law. We have the law against discrimination, which kind of sits below, in many respects, the federal law. And then we have Berkeley Township's ordinance. So the court in the Berkeley Township case said, wait a second. Under preemption theory, the superior law, to the extent it conflicts, trumps the inferior law, the junior law. So basically speaking, the court said the township ordinances would fall to state law. And to the extent they conflict, state law would fall to federal law. However, in this case, federal law and state law were more or less consistent. And the court said, as to the law against discrimination and the Fair Housing Act, they both trump the ordinance, and the ordinance has to be stricken, because otherwise you would have familial-based discrimination, because you would limit the ability of, and just some of the examples, you would limit the ability of a seller to sell to somebody underage just to own it. You would limit the ability of a seller just to convey it, for example, to his children, to either be held in trust or just to be held by the children individually for estate planning purposes. You would limit the ability of the seller to have a broad market of possible purchasers and recover as much as he can or she can for the property, in terms of limiting the marketability of the property and the amount of money they hope to gain from selling the property. You're also obviously limiting the buyers who would like to buy and perhaps flip or even rent the property, right? That's the Scott Carrico case. So the court said the ordinance cannot conflict with state or federal law, and since this ordinance does, we are going to strike it based on the discrimination grounds. Another interesting part of this case, and I think a wonderful part of this case, is the court does discuss property rights, right? And we, for those of you who did First Friday with Fran last month, we don't need to show hands, but we talked about the foreclosure, the amendments to the foreclosure process, where I believe the state has provided a process and procedure where they are stripping homeowners of the rights to surplus funds and stripping junior mortgage holders, including associations, of the money that the association would be entitled to in the foreclosure, and essentially illegally taking property of the associations and the owners in violation of the federal constitution and the state constitution, which does protect property rights. And I told you we have 2 or 3 cases pending against that law. They haven't been decided yet, but they will be shortly. But this case also talks about how this ordinance protects property rights and violates the protection of property rights under the federal and state constitution, right? So this is what the court said, and it's in the agenda here, but I'll read it anyway so we can talk about it. The right to own and dispose of real property is within the protection of the 14th Amendment of the United States Constitution and Article 1, Section 1 of New Jersey State Constitution, right? Which is a beautiful thing. The court is affirming, notwithstanding attempts, in my opinion, and you heard me talk about this last month, legislation and ordinances and so forth, trying to destroy property rights, impairing property rights. And without property rights, and there are lots of people who disagree with me on this, but without protected property rights, there can be no freedom, right? There just can't be, because if I take all your stuff, how free are you going to be, right? So the court highlighted that here. And even though the Township of Berkeley argued that the ordinance was aimed at addressing rampant housing flipping and speculation and non-owner occupants, including corporations under 55, which is making the community unaffordable for the very persons intended to serve, the court said, no, that's not enough. That's not enough. Your decision in the ordinance and passing the ordinance and limiting, in addition to violating the FHA and in addition to violating the law against discrimination, the ordinance was arbitrary and unreasonable. It is unreasonably infringing upon the well-established and constitutionally protected right to own and sell property, and it exceeded the public's need. So what the court's saying there is basically, yeah, this may be something that's good, but you just can't take away people's property rights just because you think it's good. There's lots and lots of case law out there in the United States where ordinance like this, or state laws or federal laws, have been upheld, even though they have impacted property rights and hurt the value of property. However, in those cases, the court has found that the ordinances, or what they would call the police power of the state and federal government, was so high, the need was so high that they were allowed to impact property rights. Where do you see that often most common is in easement cases, state takings cases, when the state is actually providing fair payment for the rights. You see that environmental laws and certain zoning laws too are often upheld if the state can show that there is a basis sufficient to overcome certain property rights. So anytime you see property rights impaired, the court will look at that darn carefully and make sure that whether it's a municipal entity, a state entity, or a federal entity, that the governmental entity has a very, very powerful need to do that. Otherwise, the courts will strike it down. And that's why I'm hoping so much that in the case we talked about last month, that the court will strike that new foreclosure statute, because to me, it's just an illegal taking under federal and state constitution. Here, for all of you and for all of you that I work with, you know, this case has changed nothing for us, I think it was a good suggestion that we talked about it today. And we should talk a little bit about this. So anytime a new case like this comes out that relates directly to our associations, you'll see emails flying all over the place, including my email saying, come to First Friday with Fran and let's talk about this. But you'll see these emails flying all over the place. And I noticed some emails, because I usually get the emails too, flying all over that say, you have to go out there and amend your governing documents and have a meeting and do all kinds of stuff. So with most of the governing documents I'm familiar with, the answer is no, because the governing documents, the vast majority of governing documents do not prohibit ownership. They prohibit occupancy, or they require occupancy. Another footnote we should talk about is, what if my governing documents require 100% of the homes to have one person 55 or older? Is that enforceable? Because the Fair Housing Act says only 80%. The 100% is enforceable. Yes, it is. Okay, the 80% is the minimum qualification to qualify for the safe harbor under HOPA, Housing for Older Persons Act. So you have to have a minimum of 80%. Your documents are enforceable if they have 100%, but it gives you some room to work, if you will. So the problem I've run into many times is realtors will call up and they'll say, hey, Fran, we get to sell 20% of this community to people who can occupy it who are under 55. And the answer is no. If the documents say it has to be occupied by one person, 55 or older, that is valid, because once the association has crossed the 80% threshold, the association is protected from a claim of familial status discrimination, right? So it's taking you out of that. Another question that comes up a lot of times in age-restricted communities, and this is a crazy question, but it still comes up. Well, Fran, if we meet the HOPA safe harbor for discrimination, does that mean we can do whatever we want because now we're exempt from the Fair Housing Act? No, please, God, no. That does not mean you can discriminate based on other things like race, creed, national origin, all other those prohibited things. It only applies to familial status discrimination. So just because you meet the safe harbor and it takes you out of the familial status discrimination zone does not mean you're exempt from the entire Fair Housing Act. Okay, so be very careful about that, because some people are pretty cavalier when they say we meet the safe harbor from fair housing, so we don't have to worry about it. We can be rude to people. We can treat people differently based on their race, creed, national origin, religion, etc. The answer is absolutely not. So don't even try it. So that's a cautionary thing as well. So I think it was a good topic. I don't think we have a whole bunch of questions because, again, for most of us who do First Friday with Fran, we've always addressed it the same way. If you do have governing documents that say you must be an owner, right? You must be 55 and older to own. That is probably worthwhile amending your governing documents, okay? It's probably worthwhile amending your documents to say that that's just occupancy. I don't think anyone on this call would have that in their governing documents, but you might want to check. The reason for that is it could cause title problems with closing, and it might wind up with the association getting a discrimination claim against it anyway. The reason for that is that someone could claim you're leaving that language in there, knowing that it's illegal, to purposely discourage people from even attempting to purchase units in your community. So if you have the illegal language in there, you must own instead of occupy, you should change that. I suggest you change that. Okay, like I said, most governing documents limit it to occupancy. You have a question?
And Fran, with regard to the amendment itself, I know stemming from the Radburn law and then supported by the DCA regulations that the boards can pass amendments without membership involvement if we need to change a provision to comply with state law.
Right.
I suspect that would apply to the situation at hand here.
Yeah, it would. So that's a good point, Mike. So you would not have to go out for the 66 2/3 vote. It wouldn't be subject to the 10% veto of Radburn. The board can just pass it because all you're doing is bringing your association's governing documents into compliance with law. By the way, if you're also doing that, that's a good point, Mike. So if you want to, we'll call it housekeeping, legal housekeeping. there's lots of legal housekeeping that can be done, especially with respect to Radburn and other things. But and we can talk about that another day. But in the discrimination context, where has this historically come up? Not just in the Fair Housing Act with respect to age, but with respect to race, right? So many older sets of governing documents say that the association shall have a right of first refusal to all homes, right? A right of first refusal to all homes. That's presumptively invalid under the law because historically those types of right for first refusal in the context of housing were used as a basis for race discrimination, right? So the association or the community could exercise a right of first refusal. So someone would come and say, hey, I'm buying a home in this community. And they would say, yeah, you seem like a nice guy, but I'm sorry to let you know the association decided to buy it anyway. So quite a few older governing documents have that right of first refusal provision. And you might want to think about taking that out too, just to keep the issue off the table, right? Because there could be a claim if someone was not able to purchase a home there, that chilled purchasing home because it's presumptively invalid. So yeah, Mike says, hey, can you send me the links to the two cases? Yes, Crystal will do that. Mike says, many times we are not aware of who purchases a home until they register with the management company, usually after settlement. What happens if the new owner is not aware of the age restriction and or does not qualify to live here? What can the association do versus being sued by the new homeowner who lives here? Would realtors have any liability here on selling this home and not divulging the restrictions of the property? So, Mike, that's a good question. The restriction, the valid restriction requiring occupancy is enforceable. So we've had a number of cases where we've had to unfortunately get involved in lawsuits to remove people who did not meet the age restriction, both on being underage and, as Mike pointed out, having families living there with children. You know, the first time the school bus rolls through, we get 30 phone calls. What's a school bus doing in our community? That's evil, I say. So I'm just about 60 years old now, and I have 4 kids, 15 and under. So I will never qualify to live in an age-restricted community because my kids won't be old enough, fast enough. I'll be gone. But so yes, you can enforce it. Do the realtors have liability? So a realtor might have liability. The realtor may be liable to the owner, right? The other person that may be liable, and age-restricted communities, it's pretty common knowledge these days, so we haven't had much issue with that. The other person who might be liable is the closing attorney for the purchaser. So we've seen cases like that. Usually those issues come up in the context of the pet prohibitions. So we'll have communities that have pet prohibitions, and neither the realtor nor the closing attorney advised the purchaser that there were pet prohibitions. And the purchaser will say, I am not moving out of here. So I should say, I'm not moving in here if I can't have my pet. And putting aside the reasonable accommodations for handicapped and service animals and emotional support animals, that is a real problem for the closing attorney and the realtor because that should have been explained to the purchaser. Some age-restricted communities have barred ownership by LLCs. Rationale is to support a sense of community by discouraging absentee owners. Is that valid? Is that valid after Berkeley? So Berkeley only addressed the discrimination issue. I don't think there's a claim for familial discrimination based on a prohibition of LLC ownership. So Dave, I haven't actually looked at that case in that context. I don't think Berkeley would really impact that. I'd have to look at the corporate structuring, but I think, you know, where we would see it probably more critically would be in the, we represent some co-ops as well. So we represent homeowners associations, co-ops, and condos. Where the LLC issue would come up, and I think it would be permitted rather than prohibited, is in co-ops because their monthly fee is very, very large. And in theory, LLC ownership could insulate the owner from liability for payment of fees if it doesn't pay the fees. But that's something I would have to look at a little bit more, Dave, but that's a good question. I would say as we sit here right now, don't run around and say LLCs are prohibited, because I don't think Berkeley addressed that at all. My son is listed on my deed. Does he enjoy the amenities when visiting with his family, or should he be listed as a resident? So that's Bill. Thanks, Bill. So your son would be your guest. These people would be your guests. And so it would depend on the guest policies of the association. Where that issue comes up more often than not, Bill, is golf course communities. And when the owner rents his home to a tenant, and then the owner wants to continue to golf there for free because he says, I'm an owner, I have all the rights. The answer to that is no, you don't, because when you leased it, your tenant assumed your rights as to using the property. So you can't double down. You can't double dip on the amenity usage. But they could, obviously, Bill, you could bring them in as your guest. Bill says, I was just going to, I missed that. First right of refusal is permitted in co-ops, correct? So co-ops are a bit of a different animal, Kim. The co-ops, because you don't really own the unit, you own shares in a corporation. There may be co-ops are given greater leeway, I'll put it that way, in evaluating potential purchasers. However, whether it's a co-op, condo, or homeowners association, you have to be extremely cautious. So in the co-op context, the only area where really the analysis applies is financial ability to be a shareholder in a co-op. That's the only thing that I like, having looked at. I haven't looked at the right of first refusal issue in the co-op recently. It hasn't come up, but you have to be very cautious that even if it is not being used as a pretext for racism, that you're not opening yourself to a claim that it is, right? So if someone comes into your co-op and says, hey, I have a deal, I'm going to buy here, I know I have to go through the review, and that person's a member of a protected class, which, as we've said before, many of us, almost all of us, are members of protected class these days. And you say, you know what, we've decided to exercise a right of first refusal, having nothing to do with that person's status as a protected class member, there is a high chance that you're going to wind up getting hit with a suit anyway, even if the association had no intent to discriminate against the protected class person. So you got to be very, very careful. Co-ops, the ones we work at, generally look at financial ability to own there. Aren't realtors required to divulge limitations within the communities? So Al, I don't know of a legal statute that says realtors are obligated to explain any and all restrictions in the community. I think there's a good basis of a negligence claim, a failure to exercise reasonable care if the realtor didn't go through it. So I think like I said, I think the realtors would wind up getting a suit for that, as would the closing attorney. And as we've talked about in the past, the problem with closing attorneys is, and I feel bad for them, the charges for a closing attorney to do a closing are often $1,500 or often much less, right? So it's very challenging for a closing attorney, and we don't do closings here, very hard for a closing attorney to spend hours and hours and hours on what would normally be a routine real estate transaction, reading through the restrictions in the governing document with his or her client, even though that's probably a wise thing to do. But not doing it, regardless of how much you're paid, will open you up to a claim if your client gets in trouble with a purchase and you had the governing document. So here's another example. There are many, we've had at least one case where a person bought a home, a single family home in an association, and we wound up in a litigation because the homeowner claimed that they had no idea an association existed, therefore they were refusing to pay any assessments. They obviously lost that case, but in theory, right, they could have gone back to their closing attorney and said, wait a second, Didn't you give them the governing documents? Didn't you give them that big pile of paper? And I think at times the answer is no, right? So the governing documents come back as part of the title search. The closing attorney puts them in their Redwell. They close the deal, everything's signed, and they all go home. Everyone's happy. So a lot of times I think, and again, I'm not speaking poorly of closing attorneys. I think closing attorneys do a good job for what they're paid. And they really, I think, again, to give them a little plug here, I think they should be paid much more than they are being paid now. But it becomes a race to the bottom, unfortunately. And some of them do not spend the time explaining to their clients what is actually the rules, regulations, and restrictions in communities. Are co-ops treated the same as condo associations under these court's decisions? So that's Bill. So more or less, I would say more or less. I would say 90% of the time, yes. 90% of the time, yes. So co-ops can't discriminate in housing on the same protected class status as we talked about under LAD and FHA. So FHA and LAD apply, in my opinion, equally. However, since they're not, because basically co-op, if you want to call them owners, they have an interest in a proprietary lease, which is housing, and they are going to live there pursuant to the proprietary lease. So I would argue pretty strongly that LAD and FHA anti-discrimination provisions apply to the co-op. However, co-ops do have a broader right to evaluate the people who potentially will be the proprietary leaseholders. So for example, and this is not a big deal in New Jersey because we don't get into it very much, but in New York City, this is a very, very big deal, right? It's a huge deal in New York City because not only can you consider financial in the co-op, you can actually consider the person's history. So what is a big deal in New York City with co-ops? A big deal is celebrities, right? Everyone loves celebrities until they're living next door to you in your co-op, and Madonna is living next door to you. Who wants to live next door to Madonna? No offense to Madonna, but you don't want groupies trying to come in the hallway. You don't want to have additional security because people are trying to sneak in the loading dock. You don't want all that hassle, right? Everyone knows what happened to John Lennon, God forbid, right? But so it's more, and it gets very technical in the co-op field. It's more than just financial considerations. Co-ops can actually consider things like that. Will you put an additional security load on the association? Will you and your friends and perhaps groupies and fans, etc., disrupt the association? So there's whole bodies of case law on that in the co-op context. I guess fortunately or unfortunately for us at McGovern, we don't deal with many celebrities. Even though there are many celebrities, I understand, living in the towers of Jersey City and Newark now along the Gold Coast, we haven't had any problems with them. But in the city, I know it's a hot topic in co-ops. As a realtor, I will answer with yes, we are. Some realtors are ignorant of what they need to do. Yes. Okay. So thanks, Marcia. Yeah. So is that reasonable care? So I think Marcia highlights the point. Yes. If you're a responsible realtor, if you're a realtor who does the right thing, right? If you're a realtor like the vast majority of realtors, you do the right thing. But there are a number of realtors on the call with us today. And we all know realtors, just like there are bad lawyers. There are bad realtors out there who their only mission is close the deal. And even though they know darn well that there's a pet prohibition in the building, they'll be like, ixnay on the pet A, close the deal, close the deal, close the deal. It becomes a mantra. And that is just, in my opinion, malpractice. And I think Marcia would agree with me. If the son is on the title, they should be entitled to use of all amenities since he's an owner. So the question there is, Al, so I didn't read the earlier question. My son is listed on my deed. Does he enjoy the amenities when visiting? So, and maybe I didn't understand Bill's question enough there, Al. So my understanding of Bill's question was Bill's son is the owner of the home, right? Bill's son is the owner of the home, and he is letting his father live there. So that's usually done for estate planning purposes, right? I may have interpreted Bill's question improperly, but it sounds like what you're saying, Al, is, well, what if me and my son are both on the deed, right? So we're joint owners, but only I am a resident. I have my son on there for estate planning purposes, let's say tenancy by the entirety, but I'm not a member of the community, but he's a co-owner of the property. And the reason I do that is so if I drop dead, they find me in my home tomorrow morning, I don't have to go all through kinds of nonsense to transfer it to my son and the estate and so forth and so on. It goes immediately to my son in terms of ownership. Does that mean that the son is entitled to all rights of membership? I think not. I think not. Now, that could be debatable. That could be debatable. I think not, especially, and I'm taking your example, Al, the son doesn't live with you. The reason I say that is, when lawyers try to think about things, they try to take things to extremes. And I'm the oldest of 7 children. What if my parents put the 7 children on the deed? Would that mean all 7 of us could play golf every day and we don't have anything to do with residing in the community and our parents live there? Could we have all 7 of us in the clubhouse every day? Could we have all 7 of us going to field trips and so forth for the association? I think not. But Al, I think that's debatable. I think it's debatable. I think it would the membership rights would be exercised by the residents. Okay. There's a little funky debatableness there. But I think otherwise, taking it to the extreme, it would just not be workable. So you couldn't just put your children on the deed so that they could golf every day when they're not residing in the community. Anything else? Anything else? All right. Well, I hope I covered it. I thought it was a good topic. And again, thank you so much for suggesting the topic. And if anyone else has suggestions for topics, please don't hesitate to shoot me an email and say, hey, Fran, why don't we talk about this? And I don't think I've ever turned one down. So please feel free to shoot one over. All right. Thanks again, everyone. Have a great weekend. Hopefully we'll see the sunshine this weekend. Take care.
Everybody.